Hello everyone, my name is Kirti and I am an assistant professor in ITM. Today I am going to share the concept of free consent and this is part 6 in business law. So one of the essential conditions of a valid contract is that it should be made out of free consent of the parties. It means free consent is important to determine the validity of a contract. So a contract without free consent is voidable contract. So this is the chart has been given. It is the chart where mentioned that consent should be free. It is not caused by in these coercion, undue influence, misrepresentation, mistake. The section has been given. You just note down the section through this slide. Now meaning of consent. So according to section 13, two persons are said to consent when they agree upon the same thing in the same sense. It is also known as consensus ad item, which means identity of mind. Free consent. To make a contract valid, not only consent is necessary, but the consent should also be free. Section 13 says the consent is said to be mistake. Coercion section is section 15, undue influence section 16, fraud section 17, misrepresentation section 17-18, mistake section 20-21. Then move to coercion. So coercion is committing or threatening to commit any act forbidden by the Indian Penal Code, or the unlawful detaining or threatening to detain any property to the prejudice of any person whatsoever, with the intention of causing any person to enter into an agreement, right? So for example, A threatened to kill B if B does not agree to sell his property to A. So B consent is obtained by coercion. Now is threat to commit suicide is coercion? The threat to commit suicide is coercion, yes. As per the Indian Penal Code, attempt to commit suicide is offence, but committing suicide is not an offence, right? So Madras High Court has held by a majority judgment that even a threat to commit suicide is coercion, even though it is not punishable under the Indian Penal Code. For example, a man, by giving a threat to commit suicide, induces his wife and son to execute a deed in favor of him in respect of certain property, and they execute. Held the consent of the wife and son has obtained by coercion, so it can be voidable at the option of the aggrieved party, right? Then effect of coercion, section 19. So when the consent of the party to an agreement is obtained by the coercion, the contract is voidable at the option of the party whose consent is obtained. The burden of proving that the consent was obtained through coercion shall be upon the party who want to set aside the contract on plea of contract. So if the aggrieved party has suffered from any loss, he can recover the loss from the defaulting party. Example of effect of coercion: Anuj executed transfer bond for the house under fear of assault. It will be a contract to deliver certain goods to the consignee except upon the payment of an illegal charge for carriage. The consignee pays the sum charged in order to obtain the goods. He is entitled to recover so much of the charge as was illegally excessive. Next is undue influence, section 16. So a contract is entered on undue influence when relations that exist between the parties are such that one of them is in a position to dominate the will of the other, and the dominant party uses his position to obtain unfair advantage over the other. Therefore, mere being in a position to be dominate is not enough, but the party should have obtained unfair advantage by using dominant position. So when a contract is made with undue influence, the contract is voidable and the aggrieved party can recover the damages if he has suffered from any loss because of the undue influence. So when the contract is challenged in a court of law on the ground of undue influence, the burden of proof lies upon the weaker party. Now following are the parties that can affect the undue influence: the relationship between doctor and patient, lawyer and client, guardian and ward, trustee and beneficiary, then teacher and student. There is a case, as I mentioned, under the undue influence in Karnal District Company Limited and Lalli Prasad, confirmed by the Supreme Court in 1963. The elder brother was shown to have exercised undue influence over the younger brother in respect of a compromise arrangement. Transaction was held to be voidable at the instance of the younger brother. Next is fraud, section 17. So misrepresentation of facts may be intentional or innocent. Intentional misrepresentation has been termed as fraud, and innocent misrepresentation has been termed simply as of facts which are material for the information of a contract. So the fraud means and includes the following act, like suggestion of fact which is not true by any person who doesn't believe it to be true, and active concealment of the fact, and any other act fitted to deceive, a promise made without an intention of performing it. Now move to example of fraud. Manoj was induced to buy share in a company on account of a false statement made by a stranger. It was held that he could not get out the bargains because false statement was not made by the company or his agent. Next example is Manoj says to Deepika his coat is made of pure wool. Though he knows that it is untrue, Deepika purchases the coat believing Manoj's statement to be true. It is fraud by the Manoj and therefore contract is voidable at Deepika position. Next, exception to the rule, silence is not fraud, right? But silence without any legal duty to speak will not amount to fraud except where the circumstances of the case are such that regard being had to them is the duty of the person keeping silence to speak. Second, silence is itself equivalent to speech. Third, change of circumstances. Fourth, duty to speak where contracting party responses trust and confidence. So but silence is not a fraud, but these are the circumstances, these are the cases where silence is equivalent to speech or duty to speak is necessary. So these are circumstances where duty to speak will amount to fraud. Duty to speak will not amount to fraud, except these are the cases where duty to speak is necessary. Decided case on silence is not a fraud, Hands versus Simpson. H, a commercial if he is qualified to drive a car. H kept quiet about his qualification to drive a car. S contended that H's silence is misrepresentation, but it was held that H was under no duty to volunteer the information and there was no misrepresentation. So it means it is the duty of the S to determine all the qualification of H, to acknowledge all the qualification of H, but he didn't ask anything about the qualification of H and H keeps silent. So it was held by the court that it was not a duty of the H to volunteer the information. So there was no misrepresentation. Then essential of fraud, the act must have been committed by a party to the contract or with his connivance or by agent. It should not have been committed by a stranger. Then the act must have been committed with the intention of inducing the deceived party to act upon. It implies that the assertion should be such that it would necessarily influence and induce other party. Plenty must have been suffered. Then effect of fraud. Section 19, the parties whose consent to the contract is obtained by fraud can exercise any of the following rights. He may avoid the contract or may ask for the damages suffered because of the non-fulfillment of the contract. He may insist for the performance of the contract. Then move to misrepresentation. It means false representation of the fact made innocently which is a material fact of contract. The misrepresentation includes a positive false statement made without any basis of information, a breach of duty which brings advantages to the person committing it, the inducement of mistake about the subject matter, right? So mistake has been divided into two parts. Misrepresentation, this is the misrepresentation. The contract, if there is a consequence of misrepresentation, it means the contract is voidable at the option of the aggrieved party, but he cannot sue for damages. Then move to mistake. Mistake has been divided into two parts, mistake of law and mistake of fact. Mistake of law doesn't mean mistake in the provisions of any law, but it means there is a mistake in understanding the provision of any law by the party to the contract. So a mistake of law can be further classified either as mistake of Indian law or mistake of foreign law, and mistake as to private rights of the parties treated as a mistake of fact. Here the agreement will be void in the case of bilateral mistake only. Bilateral mistake, unilateral mistake are the two types. So bilateral mistake, it means both the parties are at mistake related to the essential part of the agreement. If an agreement is entered into on the ground of bilateral mistake, the agreement is void and an erroneous opinion as to the value of the thing which forms the subject matter of agreement is not deemed to be a mistake as to the matter of fact. Bilateral mistake to the subject matter existence, identity, title, price, quantity and quality. Mistake as the possibility of performing to the contract, that is physical impossibility, and second one is legal impossibility. So physical impossibility means the goods or the thing which is not actually exist, right? And legal impossibility means the contract is not implemented legally, the concept legally it is not valid, right? Mistake of fact, the contract is voidable. A unilateral mistake means one party is at the mistake, and a contract is neither void or nor voidable except that it is a mistake as to the nature of the contract or a mistake with regard to the identity of the person. For example, A agreed to buy certain wheat from B believing that they were old. In fact, wheat offered were new. It was held that A could not avoid the contract on the ground that he had mistaken impression as to the oldness of wheat. So I hope you understand the all concept of free concept. So that's all for today. Thank you so much.